Imagine for
You
a
own
moment,
this?
you're sitting in your car.
Y'all own this property?
Okay. It's parked right in your own driveway, on your own private property.
Doesn't mean you own it.
Maybe you're just, I don't know, enjoying a quiet moment,
see your
unwinding
IDs.
after work,
Get
or
off our
perhaps
property.
sharing
Let
a
me
quick
see your
meal with a
IDs.
loved
Get
one.
off our
The engine's
property.
idling. Maybe the air conditioning's on because it's Florida. You feel safe, right? Secure, completely within your rights in your own space.
Absolutely. Your castle, so to speak.
Exactly. Then, completely out the blue, no warning, a law enforcement vehicle just drives right onto your land, past your gate, pulls up close, and before you can even really process what's happening, a deputy is right there at your window.
Right up on you.
Yeah, demanding to know who you are, asking if you even belong there, and telling you, let me see your identification. Now take that scenario, which is already pretty jarring, and push it further. Imagine being handcuffed, put in the back of a patrol car, accused of trespassing, all while you're sitting right there on your very own property.
And this isn't some kind of hypothetical we're just throwing out there for effect. Not something made up. This is a very real incident, the whole thing captured on body camera video. And it's really ignited some critical questions all across the country about individual rights, about the precise boundaries of police authority, and frankly, how those boundaries get tested, sometimes really pushed in these real-world encounters. This shocking opening, well, it perfectly sets the stage for our deep dive today.
Welcome to the Deep Dive. Today we're taking a very, very close look, almost like a forensic examination at this viral story. It's one that sent ripples, really, across social media, news outlets, everywhere. Our mission for this deep dive is to completely unpack the Marion County, Florida incident involving Freddie and Navongela Jackson and Deputy Riley Artman. We're going to meticulously peel back every single layer of this encounter. We'll explore not just the sequence of events, like what happened first, second, third, but also what was said, what was maybe implied between the lines, and most importantly, what are the core legal principles actually at play here?
And to do that, we're going to be drawing insights from multiple pretty detailed sources. We've gathered articles from respected places like Atlanta Black Star, Black Press USA, and the local station WCJB. They provided crucial journalistic accounts, the who, what, where, when.
Right, the basic facts.
Exactly. But perhaps most crucially for our analysis today, we leaned heavily on a really meticulous legal breakdown from the YouTube channel, The Civil Rights Lawyer. I mean, this channel's analysis went frame by frame through the Bodycam footage. It offers this painstaking examination, really, of the legal implications of pretty much every moment, every word exchanged.
Wow, frame by frame, that's detailed.
Incredibly detailed. So our goal, as always on the deep dive, is to extract the most important nuggets of knowledge from all these sources. We want to help you understand not just the timeline, what happened when, but why each moment matters, what legal doctrines, what constitutional principles underpin this whole situation, and maybe most importantly, what can you, the listener, take away from this for your own understanding of civil liberties and interactions with authority.
So what does this all truly mean for property owners, for, just the nature of everyday police interactions, and for our fundamental understanding of our rights in America? This deep dive, well, it's designed to give you a shortcut to being genuinely well-informed on a topic that, frankly, sits right at the heart of individual liberty. Okay, let's get into it. Let's unpack this incident layer by layer and explore how a seemingly quiet, ordinary afternoon turned into such a legal and ethical flashpoint.
Sounds good.
All right, so our story kicks off on what seems like a totally normal afternoon. We're in Marion County, Florida, specifically this area called Flemington. The date we have is June 29th, 2025. Now, this isn't like downtown Miami or Orlando. It's described as a more rural part of Florida, maybe even equestrian,
Horse country, a bit more spread out.
Exactly. A place where you generally expect maybe a greater sense of peace, definitely privacy, perhaps even a bit of solitude compared to a big city. But this particular afternoon, it turned out to be anything but tranquil for the Jacksons.
And the setting itself is absolutely key here. We're talking about the property belonging to Freddie and Navongela Jackson. And it's not just any random piece of land, it's a brand new construction site. They're building what's sometimes called a barnuminium, one of those structures where you might have living space combined with a barn or a large workshop area.
Oh, right. I've heard of those. Kind of a popular style now.
Yeah, they are. And crucially, even though it was still under construction, the property was clearly defined, it had new fencing around it, and importantly, there was a gate marking the entrance to their driveway. So while the inside might not have been fully finished, and maybe they hadn't moved all their furniture in yet, this was, without question, their legally owned property.
Okay, so ownership isn't really in dispute here, legally speaking.
Not at all. In fact, the records confirm it. Marion County property appraiser records show Navongela Jackson owned the property since way back in 2017, and her husband, Freddie, was added to the deed by 2021. So their ownership wasn't just something they claimed in the moment. It was documented, official, and easily verifiable.
Right. That's a foundational fact. And as we'll see, it becomes, well, pretty quickly and dramatically contested in the interaction. So on this specific day, Freddie and Navongela Jackson, an African-American couple, they were just sharing a quiet meal inside their car.
Parked in their own driveway.
In their own driveway, yeah. Just, as the reports say, minding their own business. Apparently, it was raining, so the car windows were up, which kind of emphasizes their desire for privacy, you know, just being in their own little bubble on their own land. It sounds like a picture of just normal life. Utterly unremarkable until, well, the intrusion.
And that tranquility was just abruptly shattered.
Right.
Deputy Riley Artman of the Marion County Sheriff's Office arrives. And right here, this is where the first critical point of contention arises. This is the premise, really, of our deep dive. Deputy Artman drove onto the property.
Drove right in.
Drove right past the gate onto their private land. Without any prior permission, no invitation, and crucially, without any observable emergency or ongoing crime that would legally justify just entering someone's private property like that. This immediate act, driving onto their land, it immediately sets up this conflict over fundamental property rights versus the limits of police authority. He then gets out of his patrol car, walks up to their vehicle.
And what's really fascinating, or maybe disturbing, depending on how you look at it, is the deputy's initial justification for doing this, what he later described to his supervisor as his hunch.
Right, the hunch.
Yeah, Deputy Artman later explained his reasoning, and this is captured on his body cam. He said he's simply driving by, saw a vehicle sitting out front running. Okay. Then he noted it was a new construction and added, and this seems like a key phrase, that those places get hit, often by break-ins. So based on this general concern about construction sites being targets, he decided he needed to investigate.
Okay, let's pause right there because this is a critical legal juncture. For a legitimate criminal investigation that justifies detaining someone, what lawyers often call a Terry stop, from the big Supreme Court case, Terry v. Ohio, the police need more than just a gut feeling, more than a general concern. They need what the law calls reasonable suspicion.
Reasonable suspicion. Okay, what does that actually mean in practice?
It means having specific, objective facts, things you can point to. Facts that, when you look at them through the lens of an experienced officer, would lead a reasonable person to believe that a crime has just happened, is happening right now, or is about to happen. A mere hunch, or just a general worry that construction sites sometimes get burglarized that simply doesn't meet the legal standard. It's too vague.
So he hadn't actually seen them do anything wrong.
Yep. Exactly. Deputy Artman hadn't observed anything illegal specific to the Jacksons. All he saw was a car, legally parked on private property. He couldn't articulate, at least not initially, any specific objective facts indicating a crime connected to them. And that's a foundational requirement for a lawful investigatory detention. This lack of a clear legal basis right from the jump, it really impacts the legality of everything that happens next. It suggests he might have been operating on an assumption, maybe a stereotype about construction sites, rather than concrete evidence related to these specific people.
Yeah, that really puts his actions in a different light from the very beginning. And it makes you wonder, right, was this a legitimate safety concern that truly warranted driving onto private property and immediately confronting the occupants? Or was it maybe an overreach, an action based on a generalized assumption about the area that then got unfairly pinned onto these specific individuals? Because his approach wasn't exactly friendly or casual.
No, not at all.
Upon walking up to the car, his immediate demand was pretty assertive. You own this property. And almost before they could answer, he followed up with a very direct, let me see your IDs. It wasn't a request, it was a demand for proof of ownership and identity right out of the gate, like you said, without any clear prior indication of an actual crime being committed by them.
Precisely. And the couple's reaction was equally direct. You can hear it in the footage. A clear, immediate assertion of their rights. Freddie Jackson immediately refused to show ID and commanded pretty forcefully, you can hear the indignation, get off our property. Then he repeated it, emphasizing their space. This is our home.
There's this palpable sense of frustration, of disbelief, of feeling invaded on their own land.
You can understand that reaction completely. But Deputy Artman, he wasn't deterred by Freddie saying, this is my property, get off.
Yeah.
He actually countered quite dismissively, according to the reports, saying something like, doesn't mean you own it.
Yeah, questioning their very presence there. Exactly. And then insisted even more forcefully, Let me see your IDs now. So the dynamic just went downhill fast, from tense to outright confrontational. They kept telling him he was trespassing, to get off their land, and that's when the deputy escalated things further. He called for backup.
Right. Stating over his radio that the couple was being uncooperative, and that specific action, calling for backup because they wouldn't immediately comply on their own property, that really solidifies the encounter as non-consensual. It becomes what the law calls a seizure under the Fourth Amendment. They weren't free to leave.
And he declared he was conducting a criminal investigation, even though he hadn't seen a crime.
Yeah. Yes. That's what he stated. He claimed he needed their identification because it was part of a criminal investigation. But again, this circles back to the core issue. What crime? What specific articulable facts supported the idea that a crime involving them was occurring or had just occurred? Without that, simply declaring it a criminal investigation doesn't magically make the detention lawful. The reasonable suspicion standard still applies. His inability to clearly state what crime he was investigating based on observed facts makes his justification seem, well, flimsy, legally speaking. It suggests the entire premise for the stop, and certainly for the subsequent detention, was potentially unconstitutional from the very start.
Okay, so as the scene continues to unfold, you can almost feel the tension ratcheting up. The dispute over his presence, his authority versus their property rights. It got heated really fast.
Oh, absolutely. You can hear Freddie Jackson's reaction escalating. Understandably, his frustration is boiling over. He says something like, "You being fucking hostile now, because you just pulled up on our fucking property and acting like we don't own it." I mean, the language is heated, sure, but it really captures their feeling of being invaded, their disbelief at being treated like potential criminals on their own land. It's a raw expression, really, of that fundamental right to feel secure on your own property.
And Navongela, Freddie's wife, seeing where this was going, she took pretty direct action herself, didn't she?
She did. Very proactively, she picked up her phone and called 911. Not to report a crime by someone else, but to complain about the deputy trespassing on their property.
Yeah.
Think about that. Calling 911 on the police officer who was right in front of you.
That takes guts.
It does. It wasn't just an emotional reaction. It was a clear, deliberate signal. They were asserting their rights, asserting their belief that they were the ones being wronged here, that they were being unlawfully accosted. She was trying to use the system, ironically, to protect herself and her husband from what she clearly saw as an abuse of authority by that same system. And all this is happening while Deputy Artman's backup is already on the way, adding this whole other layer of, impending official presence.
So during this whole escalating exchange, Freddie eventually did give the deputy his driver's license, right? Even though he initially refused.
Yes, that's correct. Despite his strong initial refusal based on principle, Freddie Jackson did eventually provide his driver's license. And crucially, that license clearly listed his address, the address of the property they were on. This is a really critical moment in the timeline.
Really critical.
Because from a purely logical and frankly legal perspective, once that identification linking the individual directly to the property was provided, the deputy stated reason for his initial suspicion. His uncertainty about whether they owned the place should have been resolved.
Right. Yeah, you'd think so. Problem solved.
The information was right there in his hand. It validated their claim of ownership. It directly answered his very first question. You own this property. At that point, the justification for any further detention related to that specific suspicion really evaporates.
You would certainly think so. It seems logical, but that's not what happened, is it? The situation took another deeply unexpected and frankly problematic turn right after that.
It did. After Freddie provided his ID, he then opened his car door. Maybe just to get out of the confined space, maybe step out of the rain, who knows, maybe just to feel a bit less trapped. But the deputy immediately ordered him, very commandingly, get back in the car now.
Even after he showed his ID proving he lived there.
Yes. And despite Freddie clearly asserting again, this is my property, Deputy Artman then physically handcuffed him, right there in his own driveway. This act, putting someone in handcuffs, immediately elevates the encounter from just a stop, maybe a questionable stop, to a full-blown detention, effectively an arrest in terms of restricting freedom. And the legal justification required for that is significantly higher.
So how did the deputy justify handcuffing him, especially after getting the ID?
Well, later, explaining it to his supervisor on the body cam, Deputy Artman claimed, somewhat vaguely, that he didn't trust him when Freddie started to get out of the car. He said he was in fear for his safety, and therefore he detained him and put him in the back of my car.
Fear for his safety? Right. Because the guy opened his car door on his own property after showing ID.
That's the claim. And while officer safety is, of course, a legitimate concern, the claim of fear needs to be viewed through an objective lens. Legally, it's about whether a reasonable officer in that situation would have objectively feared for their safety based on the specific actions of the individual. Was there anything specific Freddie Jackson did beyond simply trying to exit his own vehicle on his own property after providing identification that would trigger that reasonable fear? The body cam footage, according to the analyses we've seen, doesn't appear to show any aggressive movements, any threats, any furtive gestures from Freddie, just opening a car door.
Okay, and then comes the frisk. That seems like another major step.
Absolutely. What follows is another highly problematic moment, clearly captured on camera, the frisk. Deputy Artman proceeded to pat down Freddie Jackson for weapons, even though Freddie explicitly stated he didn't have any. This is a crucial point for our deep dive because it directly involves specific Fourth Amendment protections against unreasonable searches.
Right, you mentioned the Terry stop earlier. Is this related?
Exactly. This is the Terry frisk part. For a lawful Terry frisk, that pat down for weapons during a detention, an officer needs more than just a general sense of unease or the fact that they've detained someone. They need specific, articulable information, a reasonable belief that the individual is currently armed and dangerous.
Armed and dangerous, not just one or the other.
Correct. The standard is armed and dangerous. Freddie stated he wasn't armed. There was apparently no visible bulge suggesting a weapon. No reports indicate he made any suspicious reaching movements or threatening gestures. Nothing concrete seems to have indicated he posed an immediate danger. Without that specific, articulable belief that he was both armed and dangerous, this frisk looks like a potentially illegal search and seizure. It's another significant step beyond just detainment, moving deeper into constitutionally questionable territory.
And he was kept in handcuffs for quite a while after this, right? It wasn't just a brief thing.
No, not at all. The detention wasn't brief. Freddie Jackson remained handcuffed, sitting in the back of the patrol car for a significant period. Sources vary slightly, but they say about 15 minutes or maybe around 20 minutes or so. And during this extended time, after the handcuffing and the frisk, the deputy was still trying to verify the Jackson's ownership, even though he already had Freddie's ID with the matching address.
Still trying to verify. What more was there to check?
Well, this prolonged detention itself raises serious questions. Even if, for the sake of argument, an initial brief stop might have been deemed lawful, which is debatable here, a detention must be temporary. It can't last longer than necessary to address the reason for the stop. Once that initial suspicion is dispelled, like, say, by providing an ID that matches the property, the detention should generally end. Keeping someone handcuffed in a patrol car for 20 minutes while you continue investigating after the initial reason seems resolved. That duration itself becomes a major factor in determining if the seizure was unreasonable under the Fourth Amendment.
It's just, wow. So what was he doing during that 20 minutes? What further verification was he trying to do?
Well, he did some standard things, like radioing the car's license plate number to dispatch. Okay, standard procedure. But then he went further. He actually walked over to the front gate of the property. He noted that the mailbox clearly had Freddie's ID address on it, 13335.
Okay, confirmation right there.
You'd think. But then he saw that the fence itself had a slightly different number posted on it, 13337. And this minor discrepancy, 13335 versus 13327, somehow fueled continued heightened suspicion in the deputy's mind about whether they really lived there.
A different number on the fence versus the mailbox. Could that just be an old number or related to the construction?
Exactly. Could be any number of innocent explanations. But here's a critical detail that the comprehensive analysis from the civil rights lawyer points out. Both of those addresses, 13335 and 13327, actually map to the exact same physical location on Google Maps.
Seriously, so it wasn't even really a discrepancy?
Effectively, no. What the deputy perceived as a significant inconsistency, something he continued to dwell on as justification for the ongoing detention, was, in reality, a non-issue. It could have been clarified with a quick search on his phone or computer, tools readily available to law enforcement. It suggests he might have been looking for reasons to suspect, rather than objectively evaluating the information he had.
That's incredible. So even with the ID, even with the mailbox matching, he's still suspicious because of this other number?
Apparently so. He even called his supervisor on his cell phone, explained the situation, and kept emphasizing his belief that the numbers don't match. He mentioned he didn't know there was another house behind this, suggesting confusion about the property layout. It wasn't until he physically went over and checked the lot box, the permit box often found on construction sites.
Under the permit box, right.
Exactly. And inside that box were the construction permits. And guess what? Both Freddie's and Navongela's names were listed right there on the permits for that lot. It was only then, after physically seeing their names on the official permit documentation, that he finally seemed to concede. His words, captured on the body cam, confirmed the obvious all along. Yep, you are the property owner.
Finally, after all that, after the handcuffing, the frisk, the 20 minutes in the back of the car.
Finally. And only then was Freddie released from the handcuffs. But you could imagine the emotional impact, the sheer indignity of that whole experience unfolding on their own property. Navongela's reaction, which was also captured vividly on video as soon as Freddie was released, it just powerfully encapsulated their frustration, their sense of injustice.
What did she say?
She exclaimed, "Racial profiling. I guess a black woman can't have a nice house." That statement. It's more than just frustration. It powerfully frames their belief about the underlying motive for the deputy's persistent suspicion and aggressive actions. It adds this whole other profound layer to the encounter, moving it beyond just legal technicalities into the realm of lived experience, systemic issues, and the perception of bias.
Yeah, that really hits hard. So this brings us squarely to the core issues, the main points we need to unpack for you in this deep dive. There's the legality of the stop and detention itself, there are the intricate details around property rights, and then there's this profoundly impactful perception, or maybe reality, of racial or other forms of profiling. Let's start with that first one. Just how lawful was this initial interaction and everything that followed?
Right. It all hinges on that foundational question we touched on, the Terry stop standard. Did Deputy Artman have those specific objective facts needed for a lawful investigatory detention, or was it just that vague hunch, his observations, new construction, running car, maybe perceiving Freddie as aggressive? Later on, do those truly meet the high legal bar? Especially when there was no reported crime connected to that specific location or those individuals at that moment.
It sounds like you're suggesting probably not.
Well, the law is very clear. Officers can't just act on a feeling or a general statistic. They need articulable facts suggesting this specific person might be involved in criminal activity right then or imminently. Artman's justification about those places get hit often, that's a generalized concern about an area. It's not specific objective facts about the Jacksons themselves. It's the crucial difference between saying burglaries happen around here sometimes and saying I saw this person jimmying the lock on that door. The first one just isn't enough for a constitutional stop.
So it really does seem like the deputy was, as I said before, out on a limb legally from the very beginning, operating on maybe a generalized suspicion, not concrete evidence tied to them.
It certainly appears that way based on the available information. And this leads directly into that other crucial distinction highlighted by the civil rights lawyer analysis. The difference between a consensual encounter and a detention.
Okay, explain that again. Consensual versus detention.
In a truly consensual encounter with police, like if an officer just walks up and starts a casual conversation, you're generally free to refuse to answer questions, refuse to provide ID, unless a specific local ordinance requires it under narrow circumstances, and you're absolutely free to simply walk away. There's no legal obligation to interact.
You can just say, have a nice day and leave.
Pretty much, yes. But a detention is different. A detention is a seizure under the Fourth Amendment. It means you are not free to leave. And the moment an encounter becomes non-consensual, the moment you're detained, the Fourth Amendment kicks in, and that requirement for reasonable suspicion absolutely applies.
So how do you know which it is? How do you know if you're detained?
The crucial question a citizen can ask in that situation to clarify their status is simply, "Officer, am I free to go?" Or, "Am I being detained?"
Am I free to go?
Exactly. If the answer is no, or if the officer's actions make it clear you can't leave, like blocking your path, order you to stay, taking your keys, or certainly handcuffing you, then you are being detained. And at that point, the officer must have a lawful basis, that reasonable suspicion we keep talking about, for holding you.
Okay. And in this case, it seems pretty clear they weren't free to go, especially once the handcuffs came out.
Absolutely. The expert legal opinion strongly suggests the shift to detention here, particularly the handcuffing after the ID was provided, was highly problematic. It lacked that specific objective basis linking them to a crime. And this brings the Fourth Amendment front and center, the protection against unreasonable searches and seizures. The big questions become, was the detention justified at all? And even if you could argue for a very brief initial stop, which is debatable, was its duration 20 minutes in handcuffs after the ID was provided unreasonable? That extended time frame is a really key factor in determining if a detention crosses the line into an unconstitutional seizure.
And we definitely have to circle back to that frisk one more time, because
Yeah.
it feels like such a critical and maybe often misunderstood part of these interactions.
It really is.
We touched on it, but let's reemphasize. That frisk of Freddie Jackson wasn't just like borderline questionable. It was potentially flat out unconstitutional, right?
That's the strong argument, yes. Remember the standard for a Terry frisk.
Mm-hmm.
The officer needs a reasonable belief based on specific and articulable facts that the person is currently armed and dangerous. It's not just about general safety concerns because you've detained someone. It requires something concrete suggesting a weapon might be present and the person poses a threat.
And here.
Here, Freddie explicitly said he had no weapons. The body cam footage reportedly shows no indication, no suspicious bulge, no assertive reaching, no threatening gestures that he was armed or dangerous. Without that specific, reasonable belief meeting both prongs, armed and dangerous, the frisk itself appears to be an unconstitutional search and seizure, further compounding the potential Fourth Amendment violations that seem to permeate this entire encounter.
Okay, so beyond the stop, the detention, the frisk, this incident also really highlights the importance of property rights, doesn't it? Especially this idea of curtilage.
Yes, absolutely. The Fourth Amendment provides its strongest protection not just inside the four walls of your house, but also extends to the curtilage. Curtilage is the legal term for the area immediately surrounding your home that's considered part of the home itself for Fourth Amendment privacy purposes.
So we're talking about, like, the immediate yard, the driveway, maybe a porch, or even a detached garage close to the house, that kind of space.
Exactly. Think of it as the outdoor area, intimately connected to the home, where you have a reasonable expectation of privacy, just like you do inside.
Right.
It's that extended private space that feels like part of your personal domain, distinct from, say, an open field far from the house.
And there's legal precedent for this? Courts have weighed in.
Oh, yes. The Supreme Court has been quite clear.
Yeah.
A really relevant case is Collins v. Virginia from 2018. In Collins, the U.S. Supreme Court ruled unequivocally that police cannot enter the curtilage of a home to search a vehicle parked within it without a warrant, even if they have probable cause to believe the vehicle contains evidence of a crime.
Wow, even with probable cause.
Even with probable cause. The court said the curtilage is constitutionally protected space, and the usual automobile exception to the warrant requirement doesn't apply when the vehicle is parked within that protected zone. That's a very strong affirmation of privacy rights right around the home.
Okay, so how does that apply here to the Jacksons' property? This new construction, the barnuminium, it had the fencing, the gate. Did it qualify for curtilage protection even though it wasn't, fully finished and lived in like a traditional house? That seems like a key legal question.
It's a critical question, and likely one that would be heavily litigated if this goes to court. While the home wasn't fully occupied in the traditional sense, the legal analysis we reviewed, particularly focusing on Florida's 11th Circuit federal court precedents, notes that physical markers like fences and a gate, especially a closed gate or a locked gate, play a really significant role in establishing that reasonable expectation of privacy that defines curtilage.
Even if the gate was open in this case.
Even with an open gate, the presence of the fence and the gate itself clearly delineates the property as private, signaling an intent to exclude the public. It enhances the expectation of privacy. So the argument could definitely be made, based on Collins and similar precedents, that the deputy's initial entry onto the property, driving past the gate onto the driveway without a warrant, without any visible emergency or crime in progress, what lawyers call exigent circumstances, might already have been a violation of the curtilage, an infringement on their Fourth Amendment rights from the very first moment he crossed that property line.
So the potential constitutional issues started literally the moment his tires hit their driveway.
Potentially, yes. That's a very strong argument to be made.
Okay. And then, of course, layered on top of all these legal questions about stops, frisks, and curtilage, we have the very direct and deeply sensitive allegation Navongela Jackson made, racial profiling.
Right. Her statement, racial profiling, I guess a black woman can't have a nice house, really brings that issue to the forefront. She explicitly named it from her perspective right after the handcuffs came off. She connected the deputy's actions directly to their race and the perceived incongruity of black people owning a nice new property.
And that's an accusation that really resonated with many people who saw the video online, right? It struck a chord, perhaps reflecting similar experiences or perceptions within minority communities.
Absolutely. It speaks to a lived experience and a deep-seated concern about bias and policing, Now, the deputy, Artman, he denied this directly. He claimed on the body cam, and presumably in his report, that he did not realize they were black until after he walked up to them. His argument being essentially, if he couldn't see their race from a distance when he decided to investigate, his initial decision couldn't have been racially motivated.
Okay, that's his counter-argument.
Yes. But the analysis from the civil rights lawyer offers a really nuanced and, I think, incredibly important perspective here. It suggests that even if direct racial profiling wasn't the initial trigger, based on the deputy's claim of not seeing their race, another kind of profiling might have been at play.
Another kind? Like what?
The analysis suggests, and I'm quoting loosely here, perhaps he profiled the car. An older model Honda Accord contrasted with what looked like a pretty expensive new construction project. The idea being that the mismatch between the perceived value of the car and the perceived value of the property might have triggered the suspicion.
Ah, so not explicitly race, but maybe socioeconomic profiling, class-based profiling. Is that the idea?
Exactly. It's a fascinating and crucial distinction. It moves beyond overt racial bias to a potential subconscious bias based on perceived economic status. The older, perhaps less expensive car, parked in front of this substantial, new, expensive-looking construction, maybe it just didn't fit the deputy's mental picture of who should be there. It created an incongruity in his mind that led to suspicion.
That's a really subtle but incredibly important insight. It highlights how biases, maybe even unconscious ones, not just overt prejudice, can potentially drive these kinds of interactions. What does that suggest about the assumptions we all might make, including law enforcement, about who belongs where, based purely on appearances or socioeconomic indicators like the car someone drives?
It's a profound point, isn't it? It really delves into the realm of implicit bias. Those unconscious associations and assumptions we all carry. It suggests that biases aren't always about conscious animosity. They can be about these automatic categorizations based on perceived status, wealth, or even just what seems normal or out of place in a particular setting.
So an officer sees an expensive property, sees a car that doesn't seem to match that status in their mind, and jumps to a conclusion.
That's the potential dynamic. They might unconsciously leap to the conclusion that the occupants aren't the owners, but maybe suspects potential burglars, trespassers, whatever. This kind of profiling, while not explicitly defined by race, can still disproportionately affect certain demographics and lead to outcomes that feel just as unfair and unjust. It erodes trust, definitely, between communities and law enforcement, leaving people feeling judged, scrutinized, and targeted based on superficial factors like what car they drive, rather than their actual behavior or any concrete evidence of wrongdoing.
And didn't the police report try to bolster the deputy's justification by mentioning crime statistics in the area?
Yes, that's another piece. The report apparently mentioned something like 121 construction-related offense reports in that area over the past year. Things like burglary, criminal mischief at construction sites. The implication being, see, this is a high-crime area for this type of thing, so the deputy's suspicion was reasonable.
Okay, but let's unpack that. Does a general statistic about break-ins in the whole area automatically justify stopping and detaining these specific people in their own car, on their own property, without seeing them do anything wrong?
And that's exactly the legal challenge with relying too heavily on those kinds of general statistics. While knowing an area has certain crime patterns can contribute to an officer's overall situational awareness, it generally does not, by itself, provide the individualized, reasonable suspicion needed for a lawful stop or detention of a specific person.
It's too broad.
Exactly. There still needs to be something unique to that individual or that specific situation that links them directly to potential criminal activity. Simply being present in a quote-unquote high-crime area or being near a type of property sometimes targeted by crime, that's not enough under the Fourth Amendment to justify seizing someone. The law requires a more targeted approach based on specific facts related to the person being stopped, not just generalized probabilities about the neighborhood. Otherwise, anyone in that area could be subject to suspicion just for being there.
Right, that makes sense. So after all this incredibly contentious, legally complex, emotionally charged encounter, where does it all stand now? What are the immediate consequences? And what happens next for the Jacksons and for the sheriff's office?
Well, the Jacksons have made their intentions crystal clear. The reports state they have already contacted a lawyer and plan to file a lawsuit.
A lawsuit is coming.
That seems definite. This indicates their firm belief that their constitutional rights were violated, likely focusing on the Fourth Amendment claims related to the stop, the frisk, the prolonged detention, maybe even the entry onto the curtilage. They intend to seek legal recourse. This would typically be a federal civil rights lawsuit, often filed under a law called Section 1983, which allows individuals to sue state officials, like sheriff's deputies, for depriving them of their constitutional rights.
And what would they be seeking in a lawsuit like that? Money. Changes.
Usually, lawsuits like this seek monetary damages compensation for the emotional distress, the humiliation, the violation of their rights, plus recovery of their legal fees. Sometimes they might also seek injunctive relief, like policy changes within the department, although that's often harder to achieve. But filing the suit is a significant step, signaling their determination to hold the deputy and potentially the department accountable for what happened on their property.
And what about the Marion County Sheriff's Office? What's their response been?
Perhaps predictably, given the pending legal action, they've largely remained silent. Reports indicate the sheriff's office declined to comment on the situation. It also seems to be unclear whether the officer's actions are being reviewed internally to see if any departmental policies were actually broken, separate from the constitutional questions.
So no official word on whether the deputy faces any discipline or review.
Not publicly, no. And this lack of official transparency from the department often leaves many questions unanswered for the public. It can, fairly or unfairly, be interpreted negatively and sometimes further erodes trust, especially when a video capturing such a controversial incident goes viral.
Interesting. And wasn't there something about the deputy himself knowing this might happen?
Yes, that's another layer revealed by the Bodycam footage. Apparently, the deputy told his supervisor during their phone call that the Jacksons were all talking about suing and they're going to file a complaint anyway.
Wow. So he knew.
It suggests a recognition, on his part at least, that his actions were highly contentious and very likely to lead to formal challenges, both legal and administrative. This self-awareness, caught on his own camera, kind of adds another dimension to the incident. It indicates he understood, in the moment, the gravity of the situation and how badly his actions were being perceived by the people he had just detained on their own land.
Okay, so we've really dived deep here into an incident that started so simply, didn't it? Just a couple sitting peacefully in their car on their own property. And it escalated incredibly quickly into a handcuffed detention, seemingly driven by what the deputy called a hunch, and then this rapid unraveling of what most of us would consider fundamental rights, all culminating in that really powerful statement from Navongela Jackson: "I guess a black woman can't have a nice house."
We really have. We've explored the legal complexities around reasonable suspicion, what it is and what it isn't. We've looked at the significant implications of property rights, especially that concept of curtilage and its strong constitutional protection. And we've grappled with the incredibly fraught nature of subjective judgments, hunches, and potential biases versus the need for objective facts in policing. This whole situation serves as a potent reminder, doesn't it, of how quickly an interaction can shift from supposedly consensual to undeniably coercive, and the profound impact that shift can have on a person's sense of security, dignity, and freedom even, or perhaps especially, when they're standing firmly on their own land.
It absolutely does. This deep dive, it really makes you think hard about those lines we draw, or maybe the lines we should be drawing more clearly between legitimate, proactive policing aimed at preventing crime and the protection of fundamental individual liberties, between maintaining public order and preserving personal freedom. It raises, I think, a really important question for you, our listener, to consider. In a world overflowing with information, yet often starved for context and nuance, how might understanding your own constitutional rights, like the Fourth Amendment rights we discussed today, better prepare you for unexpected encounters with authority?
That's a critical question.
And maybe even more broadly, what is your role, what is our role in shaping a society where those rights aren't just words written down in old documents, but are consistently upheld, respected, and protected in every single interaction, every single day?
It's true. Freedom itself can be a challenging concept. Dealing with it, navigating it both as citizens asserting our rights and as law enforcement officers respecting those rights, requires constant vigilance. It requires knowledge, and it requires a deep commitment to principle over expediency or assumption. Because ultimately our fundamental rights, enshrined in the Constitution, don't just evaporate because someone else feels a sense of fear or acts on a generalized hunch. They shouldn't end where someone else's unfounded suspicion begins.
Well said. We really hope this deep dive has given you that shortcut we talked about, a path to being truly well-informed on this complex, challenging, and absolutely vital topic.
Thank you for joining us on the deep dive. Keep exploring these issues, keep asking the tough questions.